Alrighty, so it's been a minute since the kids' minute, not my minute. It's been a few days for my time zone, right? This is judicial We the People News. Okay, I'm not an attorney, I'm not giving legal advice. Just in case I give my opinion, listen up, people. It's not legal advice. Do your own research, okay? Never look straight forward, always look around you, be able to protect yourself by any means necessary. Alrighty? And, dare I say it? I thought this is more interesting because it gets into the bare bones of things that we don't normally get to look at or even hear, right? American jurisprudence, okay? Volume 1, Volume 2, all that kind of stuff, all right? But I found him, and I'm going to give you full disclosure. I have not watched this whole video, but I did watch the first 30 minutes of this, so this video is going to be fairly long, okay? But it's going to go in a little bit depth about the Constitution, American jurisprudence, and explain more details, okay? Now, that being said, if I was you, I would definitely copy this in some shape, form, or fashion. And I dare y'all, I triple dog dare y'all, to tell your attorney to put this in the courts. Alright? And then, you guys send me, the thumbs up and description of what their attorney told you. Alright? Because all these bar members, it's all conflict of interest against you, believe it or not. Alright, let's, long enough video, so let's proceed forward. What do you guys think? Alright?
So let's get into what I got here to share. This is from American jurisprudence. American jurisprudence. Jurisprudence is the science behind the law. So this is the American science behind the law. This is from the second edition, September 2016 update. This isn't some old stuff, right? This is fairly recent. This is my trip down to the law library, and I pull this stuff up on the computer and save it on my little flash drive over here and take it home so I have it. So this is the one that I keep talking about, where natural rights and civil rights have nothing to do with the establishment, support, or management of government. This is it, right here. Okay? Civil rights. In general, natural, political, and social rights distinguished. Okay? Natural rights have been described as those rights which appertain originally and essentially to each person as a human being and are inherent in his or her nature. So we'll correct these words as we go through here. As a man, mankind. Human being is defined by them as a monster. So the three main terms that you need to know. You're either a man, a whoa man, which comes with their own warning label, whoa man, and one of the people. That's it. You use it any other term than that, that's word salad. They're trying to trap you into some sort of word salad language to drag you into their jurisdiction. Jurisdiction being the words, jurisdiction, the words of that law. Juris being the law, pardon me. Juris being law, diction is the words of that law. What law are they talking about? So this is when I get into objecting to the jurisdiction and demanding proof of jurisdiction. This is exactly what I'm talking about. What words? These words right here. This is jurisdiction, okay? As contrasted to civil rights. So there's something different between natural rights and civil rights, clearly, as it states right here in the science behind the law. I'm actually going to pull this up on my phone so I can try and keep up with any comments that you might have out there or questions as we go through this. No, off. I don't want that sound. Let's see what we got here. Did it allow me to tag myself? Nope. I tagged myself. Let me pull this up. Come on. Share this. Of course not. Let me share. Copy link, yeah. Hi, Neely. Hello, Lynette, Richard, Don, and 7 others watching with us. Susan's on, all right. All right, so as contrasted with civil rights, which are given, defined, and circumscribed by such positive laws enacted by civilized communities as are necessary to the maintenance of organized government. So where do we find civil rights? That would be the Bill of Rights. Bills of Rights are merely declaratory of the common law, which I'm going to show you that in American jurisprudence. Okay? So natural rights, right? Those are creator-endowed rights. Those are unalienable or unalienable. Can't place a lien on them, and you can't take them away. Plain and simple, they cannot be taken away. Your right to life cannot be taken away from you, except by due course or due process of the law. And that would be followed under civil rights or natural rights, because naturally you have the right, per the Bible, to go through a certain process, right? It has been said that political rights are included within the more comprehensive term civil rights, but that they are differentiated in the political right, in that a political right is a right exercisable in the administration of government. This is why we have all political powers inherent in the people. The people have the right to alter, reform, or abolish anything at any time we deem it necessary, right? Because we have a very unique government. It's one of a kind. In all of existence of government, in the entire history of law and in the world history, this is the best form of government where we are self-governed. Nobody dictates to us what our natural rights are and how we exercise them, right? And then the civil rights belong to the people of the society. Naturally, you acquire those civil rights by being an American, not an immigrant, not somebody who's here illegally. You do not have these rights if you're not an American. Plain and simple, you do not have these rights if you're not an American. Okay? This comes from right here. Enacted by civilized communities as are necessary to the maintenance of organized government. If you're not an American, you have no civil rights here. These come from the civilized communities in part of the organized government, being one of the people. You can't be one of the people if you're not from here. Okay, so, or a right to participate directly or indirectly in the establishment or management of government. Now, this is where it gets good. While civil rights have no relation to the establishment or management of government, now, Beauvair's Law Dictionary from 1856 says establishment, support, or management of government. Our rights do not have anything to do. So when we're talking about civil rights have no relation to the establishment, management, of government, what does that make for natural rights? Natural rights most definitely have nothing to do with government. Political rights have also been distinguished on the ground that a civil right is a right accorded to every member of a distinct community or nation, an American, which is not necessarily true with regard to political rights. Civil rights have also been distinguished from social rights and privileges, and has been pointed out in this connection that the purely social intercourse and relations of individuals cannot be enforced by law. What? They cannot be enforced by law and are not guaranteed by any constitutional provision. Imagine that. Social rights or privileges. But we have to understand what our social rights or privileges are, right? Like drinking is a social right. Alcohol, consuming alcoholic beverages is a social right. You have to act responsibly. So here's all these cases cited in the footnotes. So if you want to do any deeper investigation into this, there they are. These ones you will have to go to the law library and get. This is the crazy part. Like I go on to Justia and I try to put these in. Google Scholar, none of these cases will show up because they don't want you to have them. Not easily accessible. I do have Blackshire versus NAACP. It's a good one. So that's the end of that document. Now, we'll get into... Why is that weird? Some more American jurisprudence. Oh, crap, bro. Please try to keep your questions focused on the subject matter at hand. I don't want to go off on tangents, but one of the questions here is then how do we get them out of the government that have already been elected? How can we get them out of Dearborn, Michigan, and Minnesota? It's called impeachment. And that's through a petition of remonstrance, to impeach them and remove them from duty because they're not supposed to be there. But you have to know the law. You have to know where it says they're not allowed to be in there because they're not an American. And they're not following American values and the law of America, the law of this nation. So, here is American jurisprudence again. This is August of 2017 update. I got this right after that. This is it's the 16th volume, American Jurisprudence, Volume 16, Second Edition, Constitutional Law, Section 98. Prohibitory language stated in a constitution is nearly always construed as mandatory. Now, Mason's Manual, Legislative Procedure, aside from the 10 principles, the first principle being the group must have the authority to take the action it purports to take. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers that they do not have. They're openly admitting that they sometimes take jurisdiction on a subject matter and create legislation that they don't have jurisdiction over. How do we address that? That's a petition of remonstrance for impeachment. Become a bad actor, bad policy. No. Not supposed to do that. But that's how we've been derelict in our duty to maintain the republic. Chapter 2, Constitutional Provisions Governing Procedure. Section 6, Clause 2, a constitutional provision regulating procedure controls over all other rules of procedure. 7, constitutional requirements concerning procedure must be complied with. Number 1, being organic in character, constitutional provisions stand on a higher plane than statutes and are mandatory. Constitutional provisions providing exact or exclusive time or methods for certain acts are mandatory and must be complied with. Constitutional provisions that are general in nature and not exclusive may be directory. Okay? So, constitutional provisions are mandatory. No ifs, ands, or buts. Okay? So this is what we're going to talk about right here. It's what it says here. Right? Constitution nearly always construed as mandatory. State versus Ham. Well, they don't even read this. Again, this is case law crap. If directions are given respecting the time and mode of proceeding in which a power should be exercised, there is at least a strong presumption that it was designed to be exercised in that time and mode only. Constitutional provisions imposing duties upon the governor and the legislature have been held mandatory. That's right. Why? Because you're the servants. We are the masters. We put it in writing. These are the instruments of government that create your emolument. Your seat in government is created by these documents right here, right? This is what the people write. That is the government. Not the people themselves, but the documents is the government. However, a constitutional article providing that all laws are to be made for the good of the whole and the burden of the state ought to be fairly distributed among its citizens presents no constitutional restraint on the legislative power of the legislature because it was addressed to the legislature by way of advice rather than a command. Well, this verbiage here is trying to give them power that they don't have. And see, that's why I go into these kinds of books in the annals of Congress, and as our founders and stuff like that met in the Constitutional Convention, and we're talking about the Bill of Rights and creating the Bill of Rights, they talk about certain things like the general welfare, right? What that actually means is their scope is very, 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 very limited, and it works one way. And it's supposed to protect the people from all things foreign to the people. That's the general welfare. Not to dictate to the people what's good for the people, but what's not good for the people is to be, right, regulated and dictated that no, we're not going to let that here. Sorry. We have to protect the general welfare of the people. That's your job, is to protect the general welfare of the people, not to dictate to the people what you think the general welfare should be. So, let's go down to section 100, which I quote from all the time, right? Right here. Volume 16, American Jurisprudence, 2nd edition, Constitutional Law, section 100. A constitution is usually a declaration of principles of the fundamental law. What was that in the Law of Nations there, Book 1, Chapter 3, Section 34? Congress, the legislature, does not possess the authority to alter the fundamental law, nor the Constitution, right? They do not have that authority. They are the servants. Servants do not dictate to the people what the law is. We lay down the law prior to creating government. For that reason alone, you have to lay down the law first. And that's why it's a declaration. Declarations lay down the law. And they come before the Constitution. And they're principles, like the plus sign, the minus sign, the division sign, multiplication sign. Those are principles of mathematics. You cannot alter those principles. If you were attempt to alter those principles, you would fundamentally mess up mathematics on a grand scale, and we can't do that. Not going to happen. Not on my watch. So, many of its provisions being only commands to the legislature to enact laws to carry out the purposes of the framers of the Constitution, or mere restrictions upon the power of the legislature to pass laws. However, it is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing, that is, operative, without any necessity for further legislation. That's why the First Amendment, or the first article of the Bill of Rights, because these are articles in addition to the Constitution as an amendment of the Constitution, it says Congress shall make no law. That's right. Congress shall make no law respecting natural rights and civil rights. Those are that's the fundamental law. You can't alter that stuff. right? There is no necessary legislation. There's no necessity there. We don't need you to legislate for us in all cases whatsoever. In fact, that's a declared act of tyranny in the Declaration of Independence. So that would be an act of treason. Okay? So, criteria which may be relevant in determining whether a constitutional revision is self-executing or not include a description of the right in detail, such as the means for its enjoyment and protection, the absence of any directive to the legislature for further action, a particular informative legislative history as to the revision intended operation, and a consistency of self-execution with the scheme of rights established in the Constitution as a whole. So this is part of the reason why James Madison, in writing the Bill of Rights, talked about how it would, the argument was made, well, why should we even do a Bill of Rights? Our rights are supposed to be self-evident at this particular point in time in history, in 1776, right? So Madison was like, well, if we were to list some, there would be people out there, tyrants, who would try to construe that as, well, these are the only rights you have, and that means that we have control over everything else. Because of everything that they've been through, they knew exactly how tyrants think, right? This is in the Annals of Congress, but it's also in the annotated Constitution under the 9th Amendment. This is the reason why Madison wrote the 9th and the 10th Amendment the way he did. There are other rights retained by the people that are not enumerated in this Bill of Rights, and they shall not be denied or disparaged, which means don't make fun of me when I claim these rights. As the law sayer and the bringer of the law, if I assert a claim of a right, don't make fun of me. Don't try to deny that. I'm saying it and I'm claiming it. And unless you have some sort of evidence to prove otherwise, that right doesn't exist, screw you. Kick rocks, dude. Get off my property. These are aggregated guaranteed rights. You're trespassing. Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills of rights, that's plural, more than one, because every state, in order to form a more perfect union, this is the way our founders thought. If we create this union, each and every state writes their own Bill of Rights. You'll find it in the first article of your alleged Constitution. It's a Bill of Rights. In history, this is how it's been done, right? You do the Bill of Rights first, then you do the Constitution. Because you have to have the law laid down before you ordain and establish the Constitution, the government, the format, what I call the instruction manual. Okay? So, constitutional provisions in bills of rights are those merely declaratory of the common law. This right here destroys every single argument that people would make that case law, stare decisis, is the common law. Yes, in England, that is the way they do it, and still do it. When you go to their parliament and do their parliamentary rules and parliamentary practices, if you prevail, whatever you create, case law, the common law of England. This is how they do it. This is what we Brexited from, because they knew how the judiciary was, and they wanted to avoid that in the American common law. And so the way our founders set up our nation, right? The Lee's Resolution separated us from Great Britain, written on June 7th, 1776, ratified July 2nd, 1776. Imagine that, 2 days before the Declaration of Independence. The Lee's Resolution is actually the document that was the separation. But again, we use declarations to lay down the law. So that's what the Declaration of Independence is about, is telling the people and all the world, right? Let these facts be submitted to a candid world, that these are hereby declared acts of tyranny. known to tyrants, which is treason in our nation now, because the way our founders set up the American common law and our American law, America as the nation. Okay? So bills of rights and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct, such as Congress shall make no law. That specifically prohibits Congress from making law regarding natural rights and civil rights, which have nothing to do with the establishment, support, or management of government. Okay? What's the Second Amendment say? The second article of the Bill of Rights, right? The right of the people to keep and bear arms shall not be infringed. There is no language there that says Congress shall have the authority to make legislation regarding this act or this section, which you'll find in other parts of the Constitution. You'll find that there are in certain amendments and certain parts of the Constitution that says Congress shall have the authority to make legislation regarding this. That language is missing from all of the Bill of Rights. Why? Because it's part of the fundamental law, the common law, principles, the stuff no man can change. Not even us. That's why we're not a democracy. That is the beauty of having a republic. We go by the rule of law. Those principles dictate the correct answer every time. I don't care about your feelings. Lady Justice doesn't care about your feelings. Law, in essence, is black and white. It is either morally right or morally wrong. Plain and simple. There is no in between. There is no gray area when we're talking about law. Murder is murder, right? You commit murder, that's a crime. That's immoral. That's a deprivation of the right to life. Fundamentally. That's at the fundamental law, the common law of America. So,
I'm going to pause that right quick on that for you, whoever lasted this long, right? Right to life, right? We see on these YouTube channels people getting tased by not getting out of the car for a non-victim, right? Right here, the law did not give that officer the license to kill or manger or torture, right? There's a due process. And I just want to kind of bring that up. You know, you see these videos. I might tase you if you don't get out of the car. I'm going to handcuff you if you don't get out of the car. Or this, that, here, and there. These lawyers and judges are bypassing the real law to violate your rights by code, statutes, rules, and regulations and put you in a corporate body. And this is where we sidetrack from, right? They're policies holders. You know, keep your hands out of your pocket for officer safety. It's my policy. I didn't sign the contract for your policies. I didn't sign the contract to take risk. You signed the contract. This does not attend to I. Right.
Clear distinction exists between the questions whether a constitution provision is mandatory or directory and whether it is self-executing or requires legislation in order to give it effect. Well, I think where it says the right of the people to keep and bear arms shall not be infringed is pretty clear and is mandatory and it is directory. You don't have the authority to make any legislation because the word infringe dictates that, right? So Clear distinction exists, right? Clear distinction. So here's some case law on that. That's all right here. You can look those up down there at your local law library. You're not going to find these on Google Scholar. You're not going to find these on Justia. You might find one or two here if you get lucky. But see right here. As to whether a constitutional revision is mandatory or directory, generally, see 97 and 99. 97 is the word shall. Imagine that, where it says shall. Let's get into that. Shall, that word shall. Is it this one? Oh, that's 98. I think it's not 97, right? Okay, the courts usually hesitate to declare that a constitutional revision is directory merely since the legislature may tend to disregard provisions which are not said to be mandatory. Accordingly, it is general rule to regard constitutional revisions as mandatory. So in general, the general rule is if it's a constitutional revision, it's mandatory. It's mandatory, it's mandatory, it's mandatory everywhere. Don't touch that shit. It's not yours. That's not your subject matter. You don't have jurisdiction over that. Leave it alone. Don't trespass upon our rights. It's been laid down. Our property. Get off of it. And not to...
Now, this is what they are supposed to be following. Judges. Hint, hint. Judges are supposed to be following this. Lawyers are supposed to be operating within this guidelines. This is their guidelines. This is actually real due process. None of this civil rules of procedure crap. Right? These are actually tend to the men and women. I mean, Jesus. This guy's not an attorney. I'm not an attorney. We know this. And I'm not a genius.
Leave any discretion to the will of a legislature to obey or disregard them unless it appears from the express terms thereof or by necessary implication from the language used that they are intended to be directory only. The presumption or rule that constitutional revisions are mandatory and prohibitory unless by express words, there must be words in there that says you have the authority over this. They are declared to be otherwise applies to all sections of the state constitution alike and is binding upon all branches of state government. This is...
Now, realize that, right? If it's not there, then it's for the right of the people. If it's not written, it's under the 10th Amendment, right? Powers delegated to